Very warm welcome to all the law learners. I, Dr. Richa, Professor School of Law, Maharaja Agrsena, Baddi, Himachal Pradesh, would like to share my thoughts on the topic Uniform Civil Code, balancing the constitutional mandate with secularism. As we all know that we live in a multi-religious, multilinguistic, multi-caste uh, country, a number of people are governed by their personal laws. That leads to the different treatment that meted out to the different classes of the people through their personal laws. There are different codes for the different communities, like Hindus are governed by the Hindu Marriage Act, Hindu Succession Act, Hindu Adoption and Maintenance Act. Just like that, the Muslims and Christians are also governed by their respective personal laws. There are many different sects and they are all governed by their own customs and traditions. So, the Uniform Civil Code, as envisages in the Article 44 of Indian Constitution, that includes inter alia the entire gambit of the family laws. The term Uniform Civil Code and its meaning came under the intense security and scrutiny during the Constitutional Assembly debates. The Muslim members were very vocal against the provisions of the Uniform Civil Code. The questions that were raised, that which law of which community were to be taken as standard by the framers. That is being discussed in the Constitutional Assembly debates. Then the chairman of the drafting committee, Dr. B.R. Ambedkar, intended to have a code which provided for the uniformity of the law in the matters of marriage, divorce, succession, etc., irrespective of their personal laws or governed by their religion or the community. Mr. M.C. Chagla, while making a vehement plea for the Uniform Civil Code, wrote, Article 44 is a mandatory provision binding the government, and it is incumbent upon it to give the effect to its provisions. So the constitution was enacted for the whole country, and every section and a community must accept the reasons, the directions given in the constitution. Now we come to a very sensitive point, that is secularism in discussion with the Uniform Civil Code. The preamble of the Constitution states that India is a secular democratic republic. This means there would be no state religion. A secular state shall not discriminate against anyone on the ground of the religion. A religion is concerned with the relation of a person with God. It is a very personal, very intimate relationship, and the state's duty is to protect that relationship, not to dictate to whom we should have that relation. So it simply means that the religion should not be interfering with the mundane of life of the individual. The word secular is not a very precise one. It has different shades in different contexts. It is opposed to the religion in the sense that the secular state cannot be a religious state. In this context, some may feel that a secular state is an anti-religious state. This is not the right interpretation. The way a secular state may be a state respecting all the religions, not protecting or not flourishing one particular religion. The strength of the religious followers doesn't matter. It is the existence of that religion which is more important to the state. So, we may say that the process of the secularization is intimately connected with the Uniform Civil Code, like the cause and the effect. In very famous case of S.R. Bommai versus Union of India, AIR 1994, Volume 3, Supreme Court Cases 1. As per Justice Jeevan Reddy, it was held that religion is the matter of individual faith, and it cannot be mixed with the secular activities that can be regulated by the state by enacting a law. The term secular was added to the preamble by way of the 42nd Amendment, but the secular spirit permeated very fiber of the Constitution since the inception. Article 25 and Article 26 guarantee the right to freedom of religion. Article 25 guarantees to every citizen the freedom of conscience and right to profess, practice, and propagate the religion. This right is subject to the public order, morality, and public health, and to the provisions of Part 3 of the Constitution. Article 25 also empowers the state to regulate or restrict any economic, financial, political, or other secular activity which may be associated with the religious practices, and also to provide for the social welfare and the reforms. The protection of Article 25 and 26 is not limited to the matter of the doctrine of belief. It extends the acts done in pursuance of religion and therefore contains a guarantee for the rituals and the observations, ceremonies, and the modes of worship which are integral part of the religion. This is very famous case, Acharya Jagdishwaranand Avdhut versus Commissioner of Police Calcutta, AIR 1984, Volume 4, Supreme Court Cases 5-2. The Uniform Civil Code is not opposed to the secularism, and it will not violate the Article 25 and Article 26 at all. Article 44 is based on the concept that there is no necessary connection between the religion and the personal laws in a civilized society. Marriage, succession, and the other like matters are of the secular nature, and therefore the law can regulate them. No religion permits the deliberate distortions. It has been made very clear in Sarla Mudgil versus Union of India, AIR 1995, Supreme Court 1531. The Uniform Civil Code will interfere only in the matters of inheritance, right to property, maintenance, and succession. And for all these matters, there will be a common law. Justice Care in John Vellamutton versus Union of India, AIR 2003, Supreme Court 2902 said, it is no matter of doubt that marriage, succession, and the like matters of the secular character cannot be brought within the guarantee enshrined under Article 25 and 26 of the Constitution. Now, coming to the judicial response towards the uniform civil. The judiciary in India has been assigned a very significant role, a very crucial role to play. When the citizens are exhausted, they don't find any way through the legislature or the executive. They have a way to look forward to the judiciary. And that is a very fine and very delicate task that is assigned to the judiciary. It seeks to establish a secular polity founded on the social justice, irrespective of the tenets of the religion. Here, we will try to find out through the extent to which the judiciary has been successful in promoting the spirit of the Uniform Civil Code as intended by the founding fathers of the Constitution. It has been found that judiciary has been very careful while resolving the sensitive issues relating to the divorce, maintenance, wherever these arose a conflict between the personal laws and the interest of the communities at large. The judiciary has always tried to manage the gap between the general provisions of the laws and the personal law. We have numerous cases, a very long list where the court has time and again insisted and reiterated the need for having a uniform civil code. Like in the year 1975, in case Bhagwan Dutt versus Srimati Kamala Devi, AIR 1975. In Bai Tahira versus Ali Fasal, AIR 1980. In the year 1981, Zahra Khatun versus Muhammad Ibrahim. In the year 1985, very prominent, very renowned case, Muhammad Ahmad Khan versus Shah Bano Begum. That paved way for this elimination of this triple talaq. Now concluding, it is pertinent to note that many of the countries to the world do have their own codified civil law applicable uniformly on all the citizens. without the fear or favor, affection or malice. The logic and the imperative of having a civil code homogeneously applied on all of its citizens, irrespective of their religion, gender, or maybe any other consideration, which cannot be overstated here. Thus, to conclude, we need to understand the importance and the need of the urgent enactment of the Uniform Civil Code. The time has come to check the constitutional validity of the personal laws and place all the personal laws under one umbrella. The personal laws which discriminate on the basis of the gender, those must be checked. The Uniform Civil Code is very important step, very prominent step towards the protection of the oppressed women, to protect their human rights. Here we are not talking about the women coming from a particular religion or a particular sect. We are talking about the religion, the women as a whole, to remove the discrimination against them irrespective of their religion or the community to which they belong to. And lastly, to make our national laws in accordance with the international instruments which are legally binding on India through the various conventions and the treaties. The stalwart secular character of our nation needs a uniform civil code for the promotion of the national unity, solidarity, and integrity.